She's not under my thumb. She's not under my thumb. So I don't hear any allegation that the bond on the first file was. I think it's ill-advised behavior, but I don't have her on a bond. Yeah. But I want to note for the record that the no contact order.
But yeah, because for Sydney.
Well, yeah, we don't need it right now.
Okay, all right.
Good. I don't know what we're doing here.
She wrote down.
Patricia's not.
No.
Yeah.
Sydney.
What are we doing on Morgan?
Judge, can defense may briefly approach, please?
Sure.
So I just wanted to explain, I think what we just do today. The process we were doing, what she doing, states me that she. lost- Yeah.
Yeah.
I had it in the rules that the cases of registry as a over per show, but then he restricts the what she sees. So I'm not sure when that changed it, but she's here, so the process we doing next hearing, but she wants to. It'll be fine. For instance, so I asked her family rate, listen, she's here today, but she does want to,
No, she wants to know also.
yeah, but she does want to appear in person, so I'm gonna ask that if there's a way this, I'm talking to her docket saying that even though it is in person.
Yeah.
Because it's easier for her to appear.
No, that's fine, that's fine. That's fine, yeah.
Thank you, Judge.
Just get a bigger date, it'll be marked sometime.
Sounds good, Judge.
All right, well, we're just gonna set another pretrial?
And then I think he needs to be arraigned on the 25 case.
Yes, Judge.
Yes. Yes. I don't have a 25 case. I got a December 24 and I got a,
No, the 25 case is in the case number.
oh. Got it. Yeah, and how did we do? Oh, okay, that's why it came in 2025, but it's a 24 incident date.
Yes.
All right. All right, so let's get appearances on Leslie Morgan.
Morning, Your Honor. Patricia Mandrack for the people, the 84488.
May it please the court, on my left, the 5634 for the record, Leslie Morgan.
Thank you. Counsel, would you waive formal reading on the 12/21/24 incident?
You wait for Morgan.
I'll enter a not guilty plea. All right, so we're gonna adjourn a pretrial out till March 19th?
Mark 19.
If they're coming back to us, they
Yeah.
want 6 weeks just for a pretrial, yes.
March 19th?
I'll be in a trial that starts that Monday.
How about the week after? 26th?
Early morning or later morning?
You said which day? I'm sorry.
Mark,
26th.
we have starting at 8:45 all the way to 10:30.
9 o'clock, please.
And Judge, I would, respectfully request that in favor of, letting Ms. Preston say, for that for that pre-trial.
Done.
Thank you.
All right, so on the April 10th incident date, we'll just continue bond. Let's talk about bond on the newer incident.
Judge, in this case, for the malicious use of telecommunications device case, I am requesting that I am going to leave the terms of bond at the discretion of the court. I would ask that another no contact order be entered. And I would ask that the court reiterate to the defendant that he's been complaining witness contact, and he has had no contact with him.
Okay.
Mr. Morgan does understand that I have contact with her. However, she does, and he showed me her, and I showed it to the prosecutor. She does what amounts, in my opinion, to harass him and his wife. Like 100 calls a day type stuff. And so we would ask the court to maybe admonish her.
She's not under my thumb. She's not under my thumb.
And Judge, I haven't talked to complaining witness about this.
Right. I think it's ill-advised behavior, but I don't have her on a bond. Yeah. But I want to note for the record that the no contact order, at least according to my records, was entered on December 24th. The telecommunications charge came out of December 21 incident date. So I don't hear any allegation that the bond on the first file was.
That's correct, Judge.
All right.
If that's, and I can, if defendant had been arraigned on before, this conversation would be very different.
Okay. All right. So what I'm going to do is I'm going to mirror the bond on the second file as to match the first file. No contact. No phone calls, no letters, no social media contact. You see her Taco Bell, you're eating Burger King. You don't have your friend call her and see how she's doing. She tracks you down and begs to meet for coffee. She can't change this order. Only myself or somebody else with a rope. Clear enough? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you violate bond? That's condition 1. Condition 2 is no other trouble, no new criminal offenses. And condition 3, you got to be in court for March 19th.
Yes, sir.
Agreed? Anything else, counselors?
I believe you said March 19th?
March 19th at 9. Oh, I'm sorry. We talked the 19th and we moved it. Good catch.
Thank you.
Have a good day. Sit.
Yeah. The one thing we got on.
I asked you to email here. Hey, Ken, you have to be here tomorrow. I'll be here.
People are on.
Believe me, I always should.
What look you like?
Well, he was worried that you'd try to get out.
Oh, I didn't say that. Well, I didn't have to wear leggings under a skirt.
We ready? Mr. Mohammed?
Yeah.
All right. If you two would put your appearances on the record for Mr. Ray Mullins, please.
Good morning, Your Honor. Mohammed on behalf of the people.
Good morning, City Anderson with the Neighborhood Defender Service, P84839, appearing on behalf of Ray Mullins, who's present in the courtroom today. Can you please state your full name for the record, sir?
Regular Mullins.
Thank you. Have a seat, Mr. Mullins. The attorneys are trained to jump up in law school. You don't have to do that. Are you ready, Mr. Muhammad?
Yes, the people called Officer Kozera. Kuzar, my apologies.
Corporal, come on up. Watch your step on my ramp. Raise your right hand. Swear affirm to tell the truth, the whole truth, nothing but the truth.
I will.
Have a seat. You know the drill. Settle in. When you're ready.
Good morning, Officer. Can you please state your full name for the record?
Nathan Kuzera.
Officer, I'm gonna take you back to the day of September 2nd, 2021. Did you work that day? And in what capacity did you work that day?
Road Patrol.
Okay, and who's your employer at that time?
City Road.
Okay, and in what capacity did you work for them?
The Road Patrol.
Okay,
Police officer.
okay, and on that day, did you work by yourself or with a partner?
By myself.
Okay, and did you work in full uniform or modified uniform?
Full.
Okay, and on that day, did you operate a scout vehicle or did you work foot patrol?
Separate.
Okay, now was the scout vehicle fully marked or semi-marked?
Full work.
Okay, and on that day of September 2nd, 2021, did your duties as a police officer take you at or near the location of North Line and Huron River Drive?
Yes.
Okay, is that located in the city of Romulus, County of Wayne?
Yes.
What took you to that location?
Let me stop you, Mr. Muhammad. You don't know this, but we do. Which North Line in Huron River Drive?
The North Line and West here.
Thank you.
Thank you. And what took you to that location?
Dispatch location. To be an accident.
Okay, and when you made that location, what did you do?
Found right, I saw. Actually, the step back, it was a reference a green Yukon and a blue Ford Explorer that was involved in the accident. No injuries reported and being reported off the side of the road. Upon arrival, heading west on Huron River Drive, and I got behind the vehicle that was on the westbound side of the road, which ended up being a blue Ford Explorer.
Okay, and you indicated that there was a traffic accident. And did you observe any damage to any vehicles when you made that location?
Yes, there were two vehicles there. The green Explorer or green Yukon and the blue Explorer. I was very damaged to.
Okay, now when you made that location and you made those observations, what did you do?
First contacted the Explorer.
Okay, now how many individuals were seated in that Ford Explorer?
One in the front drivers.
Okay, and describe the scene.
The vehicle,
The vehicle, anything that you saw.
white male was sitting in the front driver's seat, the airbag was deployed. The obvious damage to the vehicle from engine vehicle
Okay, now the individual was sitting where exactly?
in the front driver's seat.
Okay, now the individual you observed in the driver's seat, you see that person in the courtroom today?
Yes,
Can you please point to that person and point out an article of clothing that person is wearing?
sitting at the defense table.
Can you please point out an article of clothing?
Black sweatshirt.
Your Honor, please let the record reflect the witness has identified the defendant.
No,
Thank you. And so then what happened next?
I asked the driver if he was okay. She tried to reply he was, then asked him for his driver's license, registration, proof of insurance.
Okay, and what happened next?
I could smell the odor, the toxins coming from the person,
Okay,
and I seemed to kind of fumble for his driver's license. That when he's pulling out his wallet, he wasn't able to hand me his driver's license while I was looking for his insurance and registration. I also asked him for his phone number to write down from the report. The driver was able to only give me 3 of the last 4 numbers of his phone number.
okay,
Then at that point, I asked him about that. There was only 3 numbers, and driver then stopped and looked at me, stated I'm drunk.
okay. Stated what?
I'm drunk.
Okay. And then what happened then?
Made sure he was okay. Believing that the vehicle was disabled, he wasn't gonna be able to go anywhere. Asked him to relax, stay there at that location. So I go talk to the other driver, find out what happened. Then I was able to talk to that driver, get all their information, return to my car. Wrote down the information I needed from that driver, gave him a business card, was able to clear him from the scene when she was able to drive his vehicle. And then I went back to Mr. Mullins to speak with him.
Okay, and so what did you do next?
At that point, I requested that Mr. Mullins step out of the vehicle,
Why did you do that?
believing he was impaired. The
Okay, what led you to that?
smell of intoxicants from his breath. Fumbling for his driver's license. And telling me that he was drunk, which is kind of abnormal, especially at that time of day. And being behind the wheel of the car.
Understood. And so what happened next?
I asked him to.
Bless you.
Sobriety test. He said he wasn't sure if he could, he was cooperative, and he was able to exit the vehicle. He appeared a bit unsteady on his feet as he walked towards the back of the car. I asked him to step on the back bumper of his vehicle, perform the sobrieties. Excuse me. I asked him which grade he was able to complete it, and if he was able to read. He said he understood the alphabet. At that point, I asked him to recite the alphabet and stop at the letter P. He continued to the letter S. And then I asked him again about the alphabet, and he refused to complete any word.
Okay, is that indicative of anything based on your training and experience as a police officer?
Yes, it's not too often that people are actually that honest, but he appeared to be fairly impaired at that point, and unwilling to complete any more sobriety tests.
So besides the alphabets, were any other tests conducted?
I was also able to administer a preliminary breath test at
Okay,
the scene, which he consented to take.
okay, and I believe the results of that is inadmissible in court, so we'll move on. So what about any other tests besides the test?
No.
Okay, and did you recover or observe any items from the vehicle?
Yes, there were, you referred my report real quick.
Will it help refresh your recollection? Officer, when referring to your report, help refresh your
Yes,
recollection?
yes.
Okay, you can refer to your report once your memory's been refreshed.
Okay.
So go ahead. Has your memory been refreshed?
Yes, there were 2 unopened 40-ounce bottles of Budweiser in a front passenger seat of the vehicle.
Okay, and pursuant to your investigations, did you learn how much the defendant did drink?
When I asked him to step out of the vehicle, I asked him how much he had to drink. He told me he had 4 beers.
Okay. And so what did you do next after you conducted the field test?
I arrested him for suspicion of driving under the influence. Secured him back to my patrol vehicle,
Okay, and what did you do after that?
transported him to the Romulus Police Department.
Okay, and what about after that?
He read his chemical test rates and he consented to a blood draw.
Okay, and did you transport him to get his blood draw?
Yes,
Okay, and was his blood drawn?
yes.
And did you observe the blood draw? Okay, and what did you do with that after it was conducted? Was it placed into evidence?
Yes.
Okay, Judge, at this time, I'd move to introduce into evidence the MSP lab report that shows the blood draw results of the defendant pursuant to 76611.
Ms. Henderson,
Okay.
thank you. That'll come in.
No,
Your witness, counsel?
I have a couple follow-up questions for you. You indicated that you were able to observe the blood draw, right?
Yes.
And when you observed the blood draw, you were able to observe the methods that the nurse, I'm assuming.
Yes.
And can you briefly describe what those methods look like?
Mr. Mullins sat in the chair. He the nurse or phlebotomist drew 2 vials of blood from his arm. Each vial was placed in the evidence container, evidence box, and sealed prior to leaving the hospital.
And did she do anything, he or she do anything abnormal or out of the ordinary in regards to?
Not that I recall, no.
Okay, we're gonna take you back to the scene of the accident. When you arrived at that time, the cars were already parked, right?
Correct.
So you didn't actually observe anyone driving.
No.
Did you check for any cameras in the area that day?
I didn't check, but I don't believe there are no cameras in here.
Were there any other individuals on the scene that day? Aside from Mr. Mullins, whom you say was at the scene, and the driver of the other car?
That responded to the accident itself. No, I don't recall anybody else being there besides myself and partners involved.
Mr. Mohammed, any redirect?
no, thank you.
Corporal, you can step down, watch your step. Any other witnesses from the people?
No.
Any defense witnesses?
No, no.
Argument?
Judge, I believe the testimony reflects a question of fact for the prior fact. I believe, based on the testimony of the officer, you know, the defendant himself indicated to the officer that he was drunk, and then also the lab results show that he was only occupant in the vehicle. The officer indicated that the airbags were deployed and this person was in the driver's seat. So I think there's sufficient evidence for probable cause.
Ms. Henderson?
Yes, Your Honor, at this time, Mr. Mullins is currently charged with felony local DUI. To prove the elements of this, third offense, felony OWI, the people would have to produce some sort of evidence that Mr. Mullins was previously convicted of some sort of operating while intoxicated. We didn't hear any testimony today. I wasn't providing any documents in regards to any convictions that Mr. Mullins would have had. Given that information, I don't think that people have met their burden for dismissal.
Judge, it's implied when it's in the complaint, and this isn't a felon in possession charge case where we have to get a certified record of actions. I've never, since I've started as an attorney, as a prosecutor, seen a case where I have to present the prior convictions.
Is it not an element of the crime? Prior convictions?
It's implied based off of the habitual offense notice in the complaint.
Is it not an element of the crime?
It is.
And don't each and every element doesn't each and every element of a crime have to be proven beyond a reasonable or beyond probable cause today? Because I think she got you.
I don't think so, Judge. I've never heard of it.
It's a probable cause hearing.
Well, I would ask the court to take judicial notice over their own records of the defendant.
Your Honor, at this time, I would also note the court did not check the register of action, and there is not, despite what the complaint indicates, there is not a second conviction in 2012 for a conviction for Mr. Mullins, which is why I was ready to see some sort of conviction record of Mr. Muhammad today, but I haven't seen that, and I don't think the court can take, judicial notice of any convictions in the register of action, because there's one conviction in the register of action from the 2022 date.
Well, Judge, I would just point the court to see that in the complaint that we have in front of us, the OWI that occurred on September 8th, 2011 happened after the Fourth District Court. Furthermore, the second conviction that we have, the one that occurred on 07/13/2020, occurred at the 34th District Court. So in this case, both previous convictions were at this very court. So I think the court, if any court can take judicial notice, it would be this court, because both convictions happened and stem out of this court.
Response.
Again, Your Honor, I've checked the register of actions, despite what the complaint says, there isn't a conviction in the register of actions for the 34th District Court noting a conviction in 2012, or any sort of operating while intoxicated. Furthermore, there was no evidence presented today, which is what Mr. Muhammad had to bring to prove today.
Okay.
That there
So
were.
let me make sure, sorry to cut you off. Let me make sure I understand your argument. I think what you're saying is, even if our computer records show 2 prior convictions, there was no evidence of it today.
Right.
Your turn.
Well, Judge, that's why I'm asking the court to take judicial notice over their own records, and these prior convictions, these 2 occurred in this court. It didn't happen in a year.
No, I got you.
So that's my request.
All right, well, let's see what our ROA says. We have 2? Give me the dates.
I'm sorry.
The dates? Oh, you're just gonna print them out?
That's the first one. Here's the beginning of the second one.
All right, February 2, 2012. Plea of guilty. January 7, 2021, plea of guilty. So I will take judicial notice that our internal records show 2 separate guilty pleas from Mr. Mullins, just 2 separate charges. Actually, I'll give you the incident dates as well. One incident date was July 13, 2020. One incident date was September 8, 2011.
Thank you.
I'm still not sure you don't have to have evidence of it beyond judicial notice, but I'm going to bind it over and Ms. Henderson can appeal me and tell me I'm wrong. Clear? Anything else? Good luck downtown, Mr. Mullins. We'll get you a AOI date for 2 weeks down the road. But we don't give them a paper notice anymore. So your next court date's downtown 2 weeks from today, 9 a.m. Bond is continued. Have a seat, ladies. Are we ready?
Yes, Judge, I'll request a mutual order of sequestration with an exception to the officer.
All right. Ladies, you're not prospective witnesses? Back row, are you witnesses?
He's the victim and then
Okay.
the victim advocate.
Okay. All right, let's get started.
The people called Kelly Massey.